Good morning. May it please the court. My name is Lisa Glass, here on behalf of the appellant, Charlotte Durante, of counsel to the law offices of Robin Bresky, here obviously with Robin Bresky and with some of Mr. Durante's family. I'd like to save 3 minutes for rebuttal, please.
Okay.
So there are two issues in this case. One deals with the trial court's resolution of the motion to withdraw as counsel, and the other deals with the trial court's resolution of Ms. Durante's motion to discharge her counsel. The motion to discharge her counsel, that issue with the Nelson hearing, that one is relatively, in my opinion, easy to ascertain, and we can get to that without reaching the constitutional issues that arise with the motion to withdraw. If we do get to the motion to withdraw, then this is a case of constitutional significance regarding the scope of a criminal defendant's autonomy to direct her own defense when represented by court-appointed counsel, and how attorney ethics rules factor into that decision when the attorney believes that good faith chosen defense lacks merit. So if we do get to that, the resolution may require this court to decide who, the defendant or counsel, is the ultimate decision maker regarding the theory of the defense. And it also may require this court to clarify or craft protocol to be implemented by courts and attorneys to ensure that a represented defendant is afforded the opportunity to present his good faith chosen theory of defense in a way that comports with both the constitutional requirements and the attorney ethical obligations. Now, as I said before, we may not need to get to that because of the issue with the Nelson hearing. With the Nelson hearing,
Well, let me ask you though about the Nelson hearing. Doesn't for the Nelson hearing a requirement to even be invoked? Doesn't there have to be allegations of incompetency?
yes, there has to be an allegation that of ineffective assistance of counsel.
And did that happen in this case?
I believe that it did. On two fronts. One, she alleges that Mr. Montgomery, her defense attorney, said to the trial court that he was not able to concentrate on her defense. And two, she also alleged that due to a conflict of interest, Mr. Montgomery was refusing to present her chosen theory of defense. So either one of those individually would have qualified as ineffective assistance.
But there's a difference between what, arguably speaking, is a conflict where the client wants the case to be argued one way, the lawyer wants to argue it a different way. That's a conflict. That's not incompetent counsel. So
Correct.
I don't understand how there's a problem with Nelson when that seems to be the thrust of the point of the hearing is my lawyer won't argue the case the way I want to argue it. That's not an incompetence allegation. That's an allegation of conflict.
Sure. Well, she takes it one step further. I understand your point. However, she's arguing in her motion, and you have to take the motion prima facie. So on its face, does it allege ineffective assistance? So she argues that, yes, there's this conflict about that he won't present her defense, but she alleges that it's a good defense and that the only reason he's not presenting it is due to an outside conflict of interest with a third party, with a state attorney election, something like that. But the other issue was that he had told the court that he's not able to concentrate on her defense. So, and I believe there's no question that there was no Nelson hearing conducted. So the only issue really for the Nelson hearing was that threshold met that one needed to be conducted? And I would say that yes, it was met because of these two separate allegations in her motion to discharge her counsel, that each of them individually and clearly collectively constitute an allegation of ineffective assistance of counsel.
You rely on Ferretta for the proposition that the defendant has the right to choose her trial strategy and to put forth her chosen defense. It's an interesting argument, but it seems to me to be an extension of Ferretta that's just not there, because Ferretta simply guarantees a defendant the right to self-representation. There's nothing, I couldn't find anything in the opinion, Loretta case, that suggests that a defendant who's represented by counsel has the ultimate authority to direct the strategy of the case, defense strategy of the case. So if you will help me make that connection, it would be helpful.
Yes, so you're correct. I am arguing for an extension of Ferretta. And I cited a couple of cases out of some different states, Maryland and a Kansas case, where they actually did make that extension, where they said that a defense, which defense to put forth is something that should be the defendant's choice.
But in both those cases, you're probably referring to the Kansas case?
Yes,
and also
the Kansas
Maryland
and the
case.
Maryland.
Well, in both those cases, though, the Supreme Courts of those states simply reaffirmed the right of a defendant to certain constitutional guarantees, and those are just the right to, let's see, I have a little list of them, because our courts have also held that defendants do have the ultimate decision-making authority when it comes to certain rights, and those would include the right to enter a plea of guilty or not guilty, a right to waive a jury trial, a right to testify or not testify, and a right to appeal. But nowhere in those rights that are commonly recognized is a right for a defendant who's represented by competent counsel to direct the course of the trial, the trial strategy, to manage the trial, because otherwise, why would there be an attorney on the case? You know, attorneys are trained professionals, and attorneys on a case have to exercise their professional judgment in making decisions about the case. So those cases that you cited, the Kansas case, Kansas v. Cotter, and Maryland, don't have anything to do with a defendant who's represented having the right to decide defense strategy.
Sure. So,
particularly if in a case like this, where it appears that a defendant's chosen course of strategy conflicts with an attorney's ethical obligation, you know, as an officer of the court, to only put forth defenses that have some merit.
sure. I see I'm running into my rebuttal time, but that went quickly. May
Give you a
I
little
answer
more
the
time,
question?
yeah. Please do, please,
Okay,
by all
thank you.
means.
Well, as you mentioned before, there are 4 general categories so far that have been enumerated by both our Supreme Court and the Florida Supreme Court, which are the whether to plead guilty, whether to waive a jury trial, whether to testify on your own behalf, and whether to appeal. Those are the fundamental rights that so far have been enumerated. Nowhere does it say that that's an exhaustive list. And I think that when you look at the types of things that the courts have held to be fundamental rights for a defendant versus tactical decisions for counsel, you can see that the right to choose which defense to put forth falls on the fundamental right side of things. Basically, it's the things that are more of a broad strategy in the direction of the defense. Those are the kinds of things that the courts have held that defendants have the right to choose, versus something that's tactical, that's really kind of the nuts and bolts of how to present a case. Those are things for the attorney. So another way to say it is what to prove, which is something for a defendant, versus how to prove it, which is something for counsel. And I think it's important to remember that the role of counsel is not to supplant the defendant as the primary decision maker. His role is to ensure that the defendant has the tools to adequately assert his rights. And I don't think that that those 4 things, the whether to plead guilty, waive jury trial, testify, and appeal, as I said before, there's nowhere that is an exhaustive list and that these are the only things. And I think that in choosing how you're going to defend yourself, it's the defendant's right to say, this is why I'm not guilty. This is what I want to show the court about why I'm not guilty. And it's the attorney's job to say, okay, well, this is how I'm going to help you prove it.
Well, okay, in this case, the defendant wanted to put forth, all right, she was charged with, let's see, the charges had to do with organized
Scheme to
defraud
Yes.
and money laundering. And the defense that she wanted to put through was, the cert was racism. And I'm not exactly sure, you know, how that defense was going to be
Right. Well, that,
established. But do you think that the record on appeal in this case is sufficient for us to actually consider her claim that she was denied her due process rights because the court wouldn't allow her to pursue her chosen theory because the court wouldn't discharge her attorney who didn't want to pursue that chosen theory? Do you think that the record here is sufficient for us to determine that, or is this something that would have to really be fleshed out at a hearing on a post-conviction motion for ineffective assistance of counsel, where the court can really look at what the defense attorney's trial strategy ideas were?
well, I believe that it's sufficient here. I guess it depends upon whether you view this as what we were talking about before, whether this is something for the defendant versus something for the counsel to decide. If it's something for the counsel to decide, then it's post-conviction. If it's something for the defendant to decide, which is what we're arguing for, then it's something to be considered here.
So you're just talking about generally that a defendant should always have the right to decide what her theory of defense should be in a criminal case?
Especially in this case, and there are some procedural pitfalls that I wanted to bring up with how it was handled with the motion to withdraw. I've got about 1 minute left. Would you like me to address these?
Well, you're actually over a minute now. If you want to finish up real quick here, and then I'll give you a minute to rebut if you want to do that.
Okay, that would be great. Thank you. So when the trial court denied the motion to withdraw, which, you know, he has broad discretion to do so, and the rules say that even though a conflict exists, you know, depending upon the circumstances, he can still deny that motion. Our argument is that it was an abuse of discretion in this instance, but we recognize that in general he has that right to, you know, to require counsel to still be in the proceeding.
This was a sixth attorney on the case, right?
They say sixth attorney, but according to, I wrote them down, hold on.
Well, I don't want to
Yes.
take
it
away
was,
too much of your time.
okay. It was one attorney, then a private attorney, then the same attorney from the public defender's office, then she was pro se, then there was another public defender, no, I believe it was a private counsel.
Okay,
and
so
private
suffice it to say she's
So
been through several attorneys.
There's probably about 4.
Okay.
And plus her pro se. Where was I? So when the trial court denied the motion, it didn't take away the ethical conflict for the attorney, and it didn't take away the conflict between him and counsel. And when you look at the rules of ethical, you know, the Florida rules of professional conduct, and you look at the comment to 4-3.1, it says that an attorney's obligation not to present what he deems to be a frivolous defense is subordinate to the right of a defendant to present, in a criminal case, to present his defense. So you have to deal with that in some way. And the way that it needs to be dealt with, which has not really been fleshed out in case law, this is why, you know, we're arguing for, you know, somewhat of an extension of Ferretta and the laws, is that there needs to be some sort of way to balance these. The Sanborn case, you know, talks about doing narrative testimony or something like that. I know there was in the briefs there was a concern about, well, maybe she would be disruptive with the narrative testimony based on past actions in the previous trials, but that's not.
But again, that's really an ineffective assistance of counsel type issue, where, you know, you might be able to argue on post-conviction relief. Well, the attorney should have asked the court to allow his client to testify, even though he wasn't going to argue that defense, and that kind of thing. But you seem to suggest in the brief that the court should have insisted on that option. And my concern about that is, if the attorney doesn't agree that that's appropriate in this case, because possibly, you know, what she might want to present on her own defense is going to negate what I'm going to try to present to her. It strikes me that if the court kind of forces that on the defense attorney, then the court is losing its role of neutrality. So again, what strikes me is it's not really an issue of due process. The court did something wrong. That's more ineffective assistance of counsel by perhaps counsel not suggesting that to the court. So I'm still concerned that you're trying to extend Ferretta in a way that just doesn't practically work.
Okay. Would you like me to
Why don't-
respond?
yeah,
or
you can
take-
respond, and then we're going to look to your opponent.
Okay. I understand your concern. Our concern is that this was a known conflict, a conflict that had been voiced, and it was a conflict between counsel and the defendant, which the trial court said, okay, well, I'm going to allow it to proceed notwithstanding this conflict, but there needs to be a way to ascertain when you know that there's going to be an issue when you're going forward. For example, there was no inquiry into, well, what is your defense? There was an articulation by her counsel, a brief one, as to what the defense was, but nobody asked the appellant herself, well, what is your defense? There was no inquiry into how counsel may have investigated the defense, any evidence that he found to support it. So basically it was the trial court kind of taking counsel's word that, okay, well, it's a not based in fact or law without any real determination. And if you kind of look at what the court requires for a Nelson inquiry, this is sort of, I guess, the equivalent of that. So if you're going to know, if you know that you're going to proceed with a known conflict and you're going to deny the motion to withdraw, which is in his discretion, but there should be some sort of resolution as to let's flesh out this conflict and see if we can deal with it when I'm ordering you to proceed notwithstanding a conflict.
Great, thank you.
Good afternoon, Cynthia Commerce on behalf of the state. I'd like to point out under Puglisi, it says once the counsel is appointed, the day-to-day conduct of the defense rests with the attorney. He, not the client, has the immediate and ultimate responsibility of deciding if and when to object, which witnesses, if any, to call, and what defenses to develop. I'd also like to point out that this is a unique situation. Relying on Ferretta, she was given a Ferretta hearing. This happened like in March of 2012. She was actually permitted to represent herself at that point, but because of her outbursts and her behavior and inability to follow the court rules, she was appointed counsel to represent her.
Was this attorney, Mr. Montgomery, appointed as standby counsel?
He was initially, let's see, she was given a Ferretta hearing. I think she was with Bertish, and then she was represented herself. Then he withdrew, and then Montgomery was appointed, and then I believe, I'm not sure, I think he started out as standby counsel, and then he was appointed to fully represent her because of her behavior.
Does the record indicate in any way why her attorney, Mr. Montgomery, waited until the first day of trial to move to withdraw? Or had he made previous attempts to do that?
No, there's nothing on that, other than the fact that, I would point out that she always raised racism as a problem. She called you can look at the transcripts, and she was constantly calling the judge a racist, and that he was a member of the KKK and he wanted to hang her and all this. So that was her defense, which resulted in 2 juries being dismissed because these prejudicial comments that came out during the trial.
Let me ask you this though. I will tell you what at least gives me pause here is we know that for a Nelson inquiry to be required, as I alluded to earlier on just a second ago, here is incompetence. But Mr. Montgomery did say, as your opponent suggested, these are his words. Judge, I'm going to renew my motion to withdraw, and to be frank with the court, I won't be able to concentrate in the defense of this matter, and I have serious doubts whether or not even trying to pick a jury that I'm going to be able to concentrate and do due diligence and defense in this matter. Why isn't that statement synonymous with, I'm telling you right now, Judge, I'm going to be incompetent on this case?
Well, I think he went on in saying that this was going to be very, very difficult. He also pointed out that based on her behavior and failure to follow his directions, that he was having a hard time presenting the case. If you look at the entire transcript before and after those comments, you see that what he's never said, I can't do it. I'm having a very hard time because of her behavior and the fact that she won't follow my guidance, and that this is, and the judge says, I understand she's a very difficult client, but this has been presented to other attorneys. What's the difference between you and somebody else? How is this not just pushing it down the road to another attorney who's going to come up with the same conflict, the fact that they won't represent her chosen defense of racism?
So basically, you're suggesting that, that if I read on, that is prior to that quotation or even after, in the record, I'm going to find that Mr. Montgomery vacillated on that issue.
Well, I mean, he clarifies, he's never said he was incompetent. He's just saying he's having a very hard time handling this case based on her behavior. I mean, at one point she accuses him, I think, of being bought or something like that. And he says, you know, I'm a court-appointed attorney, I don't need to take this abuse. So, I mean, if you look at the full transcript before and after, you see his frustration because he's having a hard time dealing with what she wants him to do and to adequately do a defense. But, I mean, clearly under Puglisi, that's his right. Once he was appointed as attorney, he has the right to make that decision. Had she followed directions when she was appointed to represent herself, because the Ferretta inquiry was done, she was entitled to represent herself. She could have chosen any defense at that point to her peril to raise to the jury. But she proved to the trial court over and over she was incapable of following directions. She had no respect for the court. She didn't follow the rules, and so this counsel had to be appointed against her wishes to represent her, and that's not contrary to the law. That is allowed. That's not an abuse of discretion. And I think you need to look at the abuse this judge took throughout this entire trial, and he tried everything he can to work with her and to let her present whatever she needed and everything, but it just never worked out because of her behavior. And what's interesting too is she initially says she wants to discharge him, but if you see in the trial, she changes. She actually testifies at the trial, and she doesn't raise racism at that point. She doesn't go off on a tangent. She doesn't start narrating a speech. She actually goes along with her counsel's strategy and cooperates as a witness and presents a legitimate defense to this case. So, I mean, I think that's instructive. I think that her behavior later on is very instructive. And I do believe that if there is a remedy for her. If she truly believes that her rights were violated, her attorney did not adequately handle her case, a post-conviction motion is available to her. Does anybody else have a question? Okay, with that, we would ask that you affirm.
Great, thank you. Okay, we'll give you a couple of minutes here to rebut, and we'll be done.
Thank you. The quote that you read from the transcript of Mr. Montgomery is exactly the reason that there should have been a Nelson hearing. No attorney is going to come out and say, I'm ineffective, I'm incompetent, but what he was saying is that I can't concentrate on the defense. I have serious doubts about my ability to proceed here. And Ms. Durante, who was there, heard it and said, I would like to discharge my counsel because he, on the day of trial, is telling me that he can't concentrate on my trial.
Well, didn't the trial judge have a Nelson hearing? It might not have been formally called a Nelson hearing, but in fact, the trial judge, having been on this case for several years, was very aware of, all of the facts and circumstances surrounding, the problem with representation in this case, given the fact that the defendant wanted to assert a certain defense and her attorney didn't. So, in effect, it appears that the trial court did have a Nelson hearing and decide that there was no basis upon which to rule that her attorney, Mr. Montgomery, was incompetent.
There actually was no Nelson hearing. There was a hearing in conjunction with the motion to withdraw, but that hearing did not meet the requirements of the Nelson hearing. There was no inquiry into, well, Mr. Montgomery, why is it that you're going to be able not to concentrate and all of...
I think he explained that on the record to the judge.
But there still needs to be compliance with the Nelson hearing, something that may be informally addressed, maybe not in total, but you still need to comply with the requirements of Nelson. That's the due process, part of the due process issue. And regardless of whether there was another issue about which defense to present, the fact that he's saying, I can't concentrate on the defense that I'm going to present.
Well, the court really heard everything it needed to hear to determine whether or not he was incompetent under Nelson. What more could the trial court have heard in the way of any evidence for the Nelson hearing? He heard everything there was for the, he understood the attorney's position, he understood the defendant's position.
The fact remains that there were inquiries under Nelson that were not conducted here.
Which ones specifically?
Yeah, that one, right here.
What did the trial court fail to inquire about that, you know, would have been required under Nelson?
There was no discussion of, excuse me. Well, first, there was no inquiry into the determination of whether he was being effective. He didn't ask about the veracity of the allegations in appellant's motion to discharge counsel. He didn't ask about the preparation for the case, the trial preparation. He didn't ask about the investigation of any of the defenses, whether the one that appellant wanted or the one that he was going to put forth, or the investigation about any other available defenses. I mean, those are things that are required to be asked under Nelson, and they just weren't asked.
Okay, great. Thank you very much. All right, we're going to stick around here and talk to our interns about this. Everybody, we're in recess, but we're going to stick around and talk to the interns